In this series of videos, we break down the Indiana divorce process. In this video, we're going to be talking about provisional orders. Provisional hearings are the first hearings in an Indiana divorce case, and in that hearing, the court would issue what's known as a provisional order. We're going to talk about what those orders are, how to prepare for these kinds of hearings, and what you can expect. So about me, my name's Nathan Vining. I'm a family law attorney here in Indiana, and I've helped people in divorce cases throughout the state. And hopefully by the end of this video, you're going to know more about what you can do to prepare yourself for this stage of the case. So the Indiana divorce process is pretty simple. Essentially, the divorce is started through the filing of a divorce petition. From there, typically, if there's children or property issues, the court would set what's known as a provisional hearing. That's a hearing that's requested by a party at the outset of the case. And this is where the court will issue temporary orders that govern the status quo during the divorce case. So it essentially is who pays what bills, what does each party do for parenting time, things like that. The third step is discovery. And with discovery, there's certain exchanges of financial information in a divorce, and that can be done very formally or informally. It just depends on your specific situation. Step 4, a lot of times in Indiana, prior to holding a final hearing, the court would require the parties to attend mediation. And what mediation is it's a settlement conference with you, the other party, where a third-party mediator will go between the two of you and your attorneys and see if an agreement can be worked on the entire case. You are free to resolve the case through an agreement prior to mediation, but prior to setting a final hearing, most jurisdictions in Indiana will require mediation of some sort. And then the last step is a final hearing. If you're unable to resolve all or some of the issues, the court could hold a hearing where you can present evidence and make specific requests from the court. So that's essentially a brief overview of the divorce process, and we're going to be talking about step 2 here, which is the provisional hearing and provisional orders. So what are provisional agreements? They're the temporary orders designed to address issues on a temporary basis in a divorce case. A lot of times, a motion for provisional orders is filed right along with the divorce petition, and what that motion says is that there's either children issues that we need the court's input on, or there's property issues and we want to have a hearing so we can have the court issue an order that governs things during the pendency of the case. They provide structure while the divorce case is pending, so bills aren't going paid, so each parent's seeing the children, so there's support, either child support or spousal support being paid. So it's really practical hearing that provides structure. You can make an agreement at the beginning of a case to have an agreed provisional order where you say, this is the parenting time, here's who gets possession of the marital house, here's who pays what bills. Or if you guys can't agree, you actually can have a contested hearing and present evidence as to what you believe should occur during the duration of the divorce. But the important thing to know is that these are temporary. They do not necessarily live after the end of the case unless that's something the court orders or you agree to. So a lot of things can be addressed in provisional orders. It's really about your unique situation, but oftentimes you're going to see financial issues addressed, such as bill payment and things like that. Possession of the marital property is also a big issue addressed in provisional hearings. Sometimes both parties want to live in the marital residence, and you can have a provisional hearing and argue that the other person should leave the house. Or sometimes you may argue that you should remain in the house because you can't afford 2 separate residences while the case is pending. Each situation is different. You can get restraining orders on property disposition, so a lot of times the court will order that neither party use the other party's credit or dispose of property while the case is pending. You'll see orders over custody and parenting time, orders over spousal support, and really anything else needing resolved on a temporary basis. It can involve all sorts of things, such as a party needing to move things into a storage unit or selling the house or anything. Really, it's just about your unique situation. So it's important to talk to an attorney to see what you need to be considering in your case, because oftentimes divorce is a very emotional process, and it's important to have that third party, that's your attorney, who's an unbiased person who can give you solid advice through this time. There's also a couple useful things that you should review if you have children and you're going into a divorce case and you're maybe facing a provisional hearing. And the first thing that I would recommend that you review is the Indiana Parenting Time Guidelines. That's essentially used in most family law cases, and what those are they're guidelines that set out what the standard for parenting time is in Indiana. You don't necessarily have to follow that schedule, and the court may not either, but there's a lot of portions of it that will be used in your nearly every family law case, such as how transportation works, how communication works, how the holidays are split. So it's important to familiarize yourself with Indiana parenting time guidelines and think, is this the framework I want to use for my family? Or if not, where do I want to veer from that and do my own thing, and what would work with us better? So it's important to get familiar with those, so you're not just going into the provisional hearing and hearing about these for the first time, so you can request deviations from them that are appropriate for your family. The other important thing to look at is the Indiana Child Support Calculator. You can go in there and plug in your income, your daycare numbers, your overnights, and it'll generate a projected child support number based on the Indiana calculations, and you can get an idea as to what potential support could be in your case. It's also important to know, typically provisional hearings are done within the first 30 to 60 days of the case. So at this point, you may not have certain financial information. So you may say, well, I would love to prepare for this hearing, but I don't know what my spouse makes. It's important to know that a lot of counties and jurisdictions require a mandatory information exchange. So a lot of counties will have what's known as a financial declaration, where you have to list out what your monthly income and expenses are, as well as provide pay stubs to the opposing party or opposing counsel. A lot of times the county may make you provide a child support worksheet proposal for a hearing, and then a lot of times the court may actually require exchange of exhibits information prior to holding a contested hearing. So that just helps the hearing work more efficiently, because somebody's not getting surprised with exhibits and you're not reading them for the first time at the hearing. So a lot of times there may be mandatory information exchange. You're going to want to check with your county to understand what I need to have to be prepared for a provisional hearing specifically in this place. So how do you prepare for a provisional hearing? There's a lot of things that you can do. But the first thing I would recommend is just think through your living situation. Should you move, or is even cohabitation appropriate while the divorce is pending? Sometimes you may also see that the kids remain in the house and the parents switch in and out through the week, so the kids get parenting time with each parent that are just in the marital residence. The other thing I would do, I would review the finances and determine how expenses should be split and come up with a proposal. I would think about, is there a need for spousal support? Was one party not working and there may need to be some support to help the other party get started? But also think through child-related issues. There is legal custody as well as physical custody. So do you want to share decision-making? How should you split up parenting time? So I would create a parenting time proposal, and are there any specific needs for parenting time that you need to address in your situation? And then I would just think through on a broader picture, is there anything else that you may need addressed by the court on a temporary basis? Sometimes that can even include just requesting access back into the house so you can get certain important papers like social security cards, insurance papers, things like that you may have left in the marital residence prior to the divorce, and you just need to get back there and get it. So the hearing is a broad hearing and it can address a lot of things, but this is a couple of things I would think about if I was preparing for a provisional hearing here in Indiana. I touched upon this at the beginning, but it's important to know that these are temporary orders. Sometimes a divorce case can get done in 60 days, which is the minimum. Other times it may take 6 months, a year, 2 years. It's all situation dependent. You actually can move to modify provisional orders before a final decree. You just have to show that there's facts that support the need for a modification. And that's Indiana Code 31-15-4 that sets out that these can be modified. So it's important to know that they are temporary. So if, for instance, you get a parenting time order and it's not working, you may want to talk to an attorney to see what you can do to modify that while the case is still pending. So ultimately, if you are facing a divorce or you're going through a divorce and you are dealing with provisional issues, it's important to seek legal advice. An attorney, like I said earlier, is essentially a person that's separate from your situation who can give you unbiased legal advice on how to best handle your situation. So it's important to have somebody that's separate from the emotions who can give you good advice and advice you can rely on during this time. So if you have questions, feel free to give me a call or text. I'd be happy to talk to you about your situation and any provisional needs that you may have in your divorce.